I call the Honourable Leanne Dalzell.
Mr Speaker, I'm rather sad that this legislation is promoted in the way that it just has been by the government, because this bill does not do what the member actually says. The purpose statement is absolutely supported on this side of the House. The purpose of this Act is to reduce the likelihood of a victim of a violent offence coming into contact with the offender subsequent to the offender's release from prison in any case where that contact would be detrimental to the victim. To achieve this purpose, the Act empowers the court on the application of a victim, and that's something we have an issue with, on the application of a victim, to make a non-contact order prohibiting the offender from having any form of contact with the victim. What we've just heard from the member is the suggestion that this is going to resolve something that should have been resolved a very long time ago. And in fact, let me quote from the regulatory impact statement, which I have to say is dated the 12th of September 2012. So it's nearly a year old, this particular regulatory impact statement. So what's taken the government so long to address this issue, if it is of such imperative in terms of resolving the problem? Let me just read to the House why the regulatory impact statement was ordered, or why the review of the law was ordered. In response to an incident in late 2011 where an offender who had served a prison sentence for rape moved into a property next door to its victim, the Minister of Justice requested a review of the existing orders and options available to protect victims in similar situations. The bill we have before us won't protect that victim, would not have protected that victim if it had been in place at the time. And let me just read why. Clause 5 of the bill. In this Act, violent offender or offender in relation to a victim means a person who at any time has been convicted of a violent offence that affected the victim and has been sentenced to a term of imprisonment of 5 years or more in respect of that offence. That rapist was sentenced to 4 years imprisonment. So the very case that gave rise to this government's sudden concern about this particular matter is not addressed by the bill. Perhaps the next speaker from the National Party could explain why the very case that actually sparked off the review has led to a bill that would not address that case. Perhaps that would be something that they could begin with. Mr Speaker, I'm absolutely committed to ensuring that we have a legal framework that is able to address these issues, and that's why I've been such a major supporter of the regulatory impact analysis process. What we have to do is we have to learn in this House how to actually state what the problem is, what the objective is, and then we have to set out a range of options about how we might achieve that objective and work through each one of those. That's what the Ministry of Justice did for this. But does anyone know who the Ministry of Justice consulted with in relation to this particular matter? The consultation they did in order to progress this important issue was with 3 community law centres, 2 victims' representatives and the Ministry of Women's Affairs, and actually they only received 4 responses, 2 in support and 2 opposed. How on earth is that a quality regulatory impact analysis? That is nonsense. That is about coming to a conclusion and then finding a post facto justification for the decision that the government's already made. This is written in the 12th of September 2012. Don't tell me that there couldn't have been a much broader engagement with the victims' rights organisations and with others about what would be the most sensible approach. Why are we requiring the victims of crime to actually themselves go through this process? One of the recommendations was to amend the Parole Act to allow for an indefinite non-contact residential parole condition. What was wrong with that option? That would have put the onus on the state to protect the interests of victims and not put it back to the victim to go to the district court and be subject to a legal aid assessment. Why on earth wasn't this option put up as the top priority? Oh, I know why. the option is likely to result in significant cost increases to the Department of Corrections over time. That's the only reason that this one is ruled out. So I think that people on that side of the House should think very carefully about the way that they are presenting these. I want to make a comment in response to the suggestion that the rights of the perpetrators of these offences are somehow more important than the victims. So let me just read from the regulatory impact statement. There was a problem with the proposal of the Harassment Act being extended because it relied on judicial discretion to determine what is necessary to reduce the likelihood of unwanted contact in each case. A risk is that this will vary depending on the circumstances in each case, and some victims may not consider the order offers them adequate protection. This risk could be mitigated by conditions applicable to their situation being imposed. For example, in a small town where the victim and offender have support networks and live near each other, a judge may consider that making the offender move out of town is an unjustified limitation on their rights. In this situation, the conditions imposed would be designed to help the victim feel safer by preventing contact between the offender and victim wherever possible, e.g. curfew-specific prohibition from visiting certain places unaccompanied. In addition, to comply with the condition, the offender would have to be aware of the victim's location, which would increase the fear and anxiety a victim has in regards to the offender. So that issue was raised by the Ministry of Justice, and I just want to tell a story about a conversation I had. When I first arrived here in Parliament, I was an associate spokesperson on justice, and we made a decision to travel around all the different prisons in order to get a real sense of the whole of the justice system. And I recall a conversation that I had with a prison officer back then, and he described what actually has become the process of restorative justice, but it was initiated by the victim of a terrible rape. The two rapists who were completing their sentence were about to go home to small town New Zealand. So stop thinking about victims as just being in large cities or towns where people can have freedom of movement. In a small town, this is very real. So this is a real story. This woman approached the prison and she said she wanted to meet the rapists before they returned to her small hometown. And the prison service was not used to this. They were very concerned about what that might mean. So they arranged for the meeting to occur after much discussion. And the real reason that they agreed to it was her motive in meeting with them. The trouble was that they pleaded not guilty. And coming back to that hometown meant that the town was divided. Half of them believed her and half of them believed them. Half of the people in her town believed that she'd made up the story of being raped, and she wanted to confront them before they came home and re-entered that whole victimisation process where she was a victim of the town's opinion, half of the town's opinion. She sat there in that room with those two, and this was reported to me by the guy that observed this happening. She looked at them and she said, "You're coming home. You must tell the truth. You've served your time. Tell the truth now." And they admitted for the first time that they had raped her. Now that to me is much more meaningful, much more real, and much more beneficial to the whole of society than anything that this bill will ever do. How dare the government put it back on the victim to sort this out? Why doesn't the state play its role and protect the victim? They could do that with an amendment to the parole legislation, and I believe that that is what the Select Committee has got to seriously look at in considering the future passage of this bill.